Welcome. Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. Look, we're still twisting this. We've been looking at how the court has taken, we have the simple words of First Amendment. The court fashioned some basic rules. Then, as we look more closely at some of the rulings, we see the court doing a bit of a twist on some of the principles, perhaps, that we started out with. As I said before, when I started thinking about these concepts, it reminded me of Chubby Checker and doing the twist. You remember the dance craze? Let's do the twist and all of that. Come on, baby. And so here we see that a twist happens, and some of the rules we had to text, then we had some basic rules. The rules become a little bit going round and round. And from the earlier clips and from this one, I think you will see what I mean. And if you think I'm making it up because it may sound a little odd, I've given you the names of the cases so you can go and read for yourself. Okay, so this clip, we're still twisting as we examine commercial speech and corporate speech. So let's go back to the general rules and see how the court twisted things a bit to address commercial speech, and then maybe twist it again to examine corporate political speech. So we have the general rule that pure speech is protected from content regulation unless the government can meet a very high standard, compelling governmental interest, and the regulation is narrowly tailored to that interest. We also have a rule, a general rule, that some speech fits in unprotected categories. Unprotected categories mean that government can, if it chooses, it may regulate unprotected speech at a lower level, not the high level, a lower level called rational basis, rationally related to a legitimate governmental interest. But then we saw how that general rule got twisted maybe or convoluted a bit with a case when we talked about hate speech, RAV versus St. Paul. But that's going back. Now, what we're going to look at in this video is commercial speech. And where does commercial speech fit? Does it fit in the in the protected speech category where government can regulate it only if it shows compelling interests and the regulation is narrowly tailored? Or does it belong in an unprotected category where government may regulate it more freely? Where do you think commercial speech fits? You got it. Did you say somewhere in the middle? There you go. That's what the court held. So the initial case is called Virginia State Board of Pharmacy versus Virginia Citizens Consumer Council. Virginia, and I have the information in the text box so you can Google the case and read for yourself. Virginia had a law, and they sought to keep pharmacists from advertising the prices of various drugs. So here they were concerned. They said pharmacy, like other professions, consumer choices should not be based just on a price, but on the total package of also the services you receive from a pharmacist. So the court had several options here. The courts could have held that commercial speech is fully protected and that the only way government can regulate it is if it has a compelling governmental interest and the regulation is narrowly tailored to that interest. Or the court could have held that commercial speech presents other problems, and therefore it was going to hold that it was unprotected speech that government could regulate more freely. The court ended up doing something in the middle in terms of commercial speech. In deciding to place commercial speech in the middle category, remember, includes near obscene, where they're concerned with secondary effects. The middle category also includes content neutral, reasonable time, place, and manner regulations. And later we're going to look at some other things that have been placed in the middle. For now, the court is saying commercial speech fits in the middle. On the one hand, the court said that there, of course, are arguments that consumers, they don't want the government to be so paternalistic or maternalistic. They want information. They want the free flow of ideas. But on the other hand, some information that would induce consumers to only make decisions for drugs and prescription drugs based on prices could in itself lead to great harm to the consumer. So the court placed the speech in the middle after it considered some cases like, do you remember New York Times versus Sullivan, where there was a paid editorial ad for the civil rights movement and the court protected that speech? The court says, so we're going to have to give commercial speech some protection, but not the highest protection. So it placed commercial speech, commercial advertising in the middle. Then it did the twist. Okay, and guess what group caused the court to do the twist? The court did the twist when it started to evaluate a case involving attorney speech. And the court was looking at anti-solicitation requirements of some bars, some state bars, that said that attorneys should not, for example, chase ambulances, go to the hospitals, soliciting business when individuals are sick or have been injured. There may be the possibility of great harm in that inducement. So the test didn't come out real clear, at least not to me, but the court said that a state can ban solicitation in person solicitation by attorneys. But then it did the twist again. And the court said there was a case where a nonprofit group, the attorney was seeking to find a plaintiff. They were challenging some of the sterilization practices. They wanted to challenge some sterilization practices of women. So they were in search of plaintiffs who had suffered in that way. And the court said that was okay. That was okay to do that in-person solicitation by an attorney, because the attorney was not trying to pad their own bank account. Rather, the attorney was working for a nonprofit and seeking to vindicate civil rights and liberties. And I've given you the names for these cases at the bottom. So it seems that where attorneys are concerned. And I'm an attorney, but it seems where attorneys are concerned, the court is rather concerned about that in-person solicitation and the possibility that consumers could be taken advantage of when they're vulnerable from injury or hospitalization. So maybe lawyers have a little less in terms of speech rights, commercial speech in the middle. Maybe attorney speech a little bit off to the side. That is something to think about. But I put the links, and if you Google those cases, you can read more about them. So let's go back. Commercial speech fits in the middle. But then the court said, okay, we have to come up with a test. What is the test for this commercial speech? In a case called Central Hudson Gas versus Public Service, a 1980 case, the court articulated the test for commercial speech. Okay, so it said first, for commercial speech to fit here in the middle and not in the unprotected, but here in the middle category, the court said it must be for lawful products or activities. So if you're advertising for a business that is illegal, then it seems your speech does not fit in the middle. So for commercial speech for a lawful product or services, and if the commercial speech is not false or misleading. Now, if the commercial speech is false or misleading, government can regulate it more. Government may regulate it more. So it must be for lawful activity, and it must not be false or misleading in order to protect the people, to protect the public. Now, if it meets that test, then a mid-level test applies. And the court articulated the mid-level test in this way. It says, then it is evaluated in the middle. Government may still regulate it if the governmental interest is substantial, and if the regulation advances that interest and is no more extensive than necessary. Now remember, fully protected speech, in order to regulate it, the governmental interest must be what? Compelling. Unprotected speech, the government has more leeway. The governmental interest only has to be legitimate. But here, in the middle, the governmental interest has to be substantial, which is less than compelling, but more than legitimate. Put that down in your notes and see what that looks like, okay? Now, but the court was not through twisting. What is commercial speech? I mean, some advertising about products or about the price of the products or what have you may seem to be commercial. But is it possible that some ads may really seem to be commercial in nature, but really they are political in nature? And some speech by companies may appear to be political in nature, but really it's about the finances. Really, it's about the economics of a given company. So the court ended up twisting again. And I was looking at Chubby Checker's song, Let's Do the Twist, And this phrase came to mind before I tell you about the final case. It says, my daddy is sleeping and mama ain't around. Yeah, daddy's just sleeping and mama ain't around. We're gonna twist, a twisting till we tear the house down. Now, you know what case is coming next. Citizens United. I'm sure you've heard a lot about that case, Citizens United. Some people really like Citizens United and say about time. And some people say, like this song, they use the words here, they're tearing the house of democracy down. So let me just tell you briefly, Citizens United, briefly, it really gets into election law. But in Citizens United, the court held that even corporations have a right to political speech. And so therefore, corporate political speech, government can still regulate it, but government must satisfy that high exacting scrutiny. But how do we distinguish between corporate commercial speech and corporate political speech? Are they really that difference? And what does this mean for shareholders who do not endorse the politics of the corporation? They like the product, they're making money, but not for the company to take a given political stance. But when the court held this, there were a lot of people who said, oh, good. Some said, not much difference. And others said, oh, no. There were some who feared that if corporations now have a right of political speech, what will they have next? Will corporations have a right of privacy, which means individuals may not get the information, consumers may not get the information? Would corporations with their right of political speech, could that then cause more harm to our democracy and our democratic process of selecting leadership? Are you doing the twist yet? Look, I put the names of the cases down in the boxes so you can take a look for yourself. My whole point is that the First Amendment has a text. Then the court laid out some rules and principles. But now we can see, now that we understand the rules and principles, we can see how the court does the twist. And so learning is so important. Learning is a pathway to enlightenment, and enlightenment to freedom. And freedom, oh my, is all about justice. And my hope is that these clips will give you some things to think about and will help my students as an additional review who are studying remotely. My hope is that if they don't lead to full justice, which would be nice, they would at least bring a taste of justice. All interpretations here are my own. I'm a professor of law at Mississippi College School of Law for informational purposes only. Okay, subscribe and sign up for notifications. Thank you. Goodbye.